said no to all that. And in 1930, he joined the judiciary. In the judiciary, at a very young age of, I would say, sometime in his 30s, he was selected, he was elevated to the High Court. I'm sorry, there's so much, so many microphones, I can't even hold this. What do I do? Thank you. I'll have to minimize my requirements. So he was elevated to the judiciary at the age of 41 in the High Court, Lahore High Court. Within 7 years, ladies and gentlemen, he distinguished himself and he was elevated to the Federal Court of Pakistan. I have spent a total of 19 years in the judiciary in the High Court and the Supreme Court. Justice Cornelius spent 17 years in the Supreme Court of Pakistan. He was one of the longest serving Chief Justices of Pakistan from 1960 to 1968. And in times that were difficult, because Pakistan was an embryonic state, it was growing, it was trying to grapple with all the difficulties of a young country, and of course there were political issues. In 1955, Justice Cornelius, who was by then in this, it was called the Federal Court. In the following year, when the Constitution came, it became the Supreme Court in 1956. In the Federal Court, he was the lone voice which said that the dissolution of the Assembly, Constituent Assembly, by the Governor General was illegal. That judgment today is hailed as an outstanding rendition of justice, for the reason that the majority decided that the Sindh High Court did not have the jurisdiction to decide the matter, and therefore there was no judgment of the Sindh High Court which could be assailed. It was an illegal judgment. The majority allowed technicality to avoid the truth. And when truth was avoided, justice was avoided. Today, one man's voice is celebrated in our circles. The rest of the men, although they include many distinguished jurists, the majority are not mentioned at all. This is the course of history, and this is the message to any judge who wants to stay on the right course. The course written for us, dictated to us, directed to us by none less than the Almighty through the Holy Quran. But that was not all about Justice Cornelius. He was a simple man. Today I am informed that he stayed in one room for 40 years. He lived there simply. He had no assets when he retired, and from his pension he paid the bills of this hotel. It was in this hotel where he lived. And I went and saw that room just now, a short while ago. But another beautiful thing about him. In 1968, he was to retire in May of 1968. But his colleague, Justice S.A. Rahman, who had worked with him for years in the Supreme Court, was to retire before then. So in order that Justice S.A. Rahman may become Chief Justice also, do you know what Justice Cornelius did? 2 months prior to his retirement, he resigned from office. He sacrificed. This was a man who had the capability to give and to share. These are the qualities which I submit respectfully judges must have if they have to do justice. I feel inspired by that gentleman because he wrote brilliant judgments also. I just mentioned you the 1955 judgment in the Tamizuddin case. Then there was this famous Doso case in 1958, which is the one that legitimized martial law for the first time in Pakistan. But an offshoot before the court in that case was whether fundamental rights that had been violated prior to the martial law and the cases were pending in the courts, whether those petitions would abate or continue to be enforced. The general tendency was that everything is closed. The constitution is abrogated and a new legal order has started. But Justice Cornelius wouldn't believe that. He said, but this happened before the abrogation took place. These rights for fundamental rights accrued and were claimed before the abrogation took place. So even after the abrogation, those fundamental rights will be enforced. And this is the way the gentleman conducted himself. He did something similar in Abul Ala Maudoudi's case in 1964. Two provinces in the country, at that time East Pakistan and West Pakistan, decided to abolish the Jamaat-e-Islami. It was an executive order, opinion of a government servant or an executive officer, whoever it was, declared that this political party should be abolished. There was one view projected by the government that that the fundamental rights did not protect the party, and that the opinion given was reasonable, it was fair, it could be seen, it could be determined, and therefore no interference should take place. Justice Cornelius held that this case does not concern the propriety of the order only. This case concerns the fundamental right of freedom of association. And if the political right to associate has been defeated in this party's case, then that's a breach of the fundamental right, and no executive officer, no government authority can sit in judgment on the fundamental right. It is the court which does that. And the result was they lifted the ban. The Supreme Court was together on that. He was the Chief Justice at the time. They lifted the ban. I could say much more about him, but I want to move ahead. I want to move to the subject which may be of interest to you. And this is the subject of minority rights in Pakistan. मेरा वो पानी का गिलास बोतल दे दो. Thank you, जी, I'm good. Our constitution, as Ms. Sabahat just told us, assures freedom to profess religion, to manage religious institutions, subject to public order and morality. Our Constitution in Article 21 safeguards particular religions against taxation for the purposes, it safeguards against taxation for purposes of any particular religion. So for no particular reason can other religions be taxed. Article 22 safeguards educational institutions in respect of religion, etc. No religious instruction or ceremony in educational institution other than one's own religion is to be given to the students. No citizen can be denied admission to educational institutions which receives aid from public revenues on the ground of race, religion, caste, place or birth. Basically, our constitution says everyone is free to profess their religion. All citizens have equal rights. There is no discrimination amongst them. And yet, for years our minorities have felt discriminated, have felt sidelined, marginalized. It is in these circumstances, in the year 2014, some 9 years ago, the Supreme Court, under the charge of Chief Justice Tasadduq Hussain Jilani, who sits with us right here, took up this challenge and came up with directions to protect the rights of the minorities. There were several directions that were issued. Directions about curriculum, directions to ensure that there is no hate speech on social media against minority religions, directions that a National Council for Minority Rights be established, a task force be established, and a special police force be established to protect religious places of worship. A job quota for minorities at 5% be ensured, and similarly an admission quota in educational institutions be ensured. For many years, these directives were carried out under the charge of Mr. Cheif, who sits right here. That was a one-man commission. He worked strenuously, selflessly, and achieved many objectives. I may agree with Sabahat, there is a lot more to be done. But pursuant to that judgment, there was movement and a great deal was done. Today, the minorities see that judgment as an umbrella which protects their rights. Today, the Supreme Court acts as a facilitator vis-à-vis the government authorities who have been cooperative. We must not overlook the fact, ladies and gentlemen, we have been through at least 3 decades of extremism. We have lost 80,000 citizens in this country to extremism. And by the grace of God, the situation is improving, and a lot of the complaints regarding violence which the minorities had, and even Muslims had, because of sectarian rivalries, they have diminished. I think that resilience which the Pakistani nation has shown through these turbulent times is a great credit to the people of Pakistan. And with great respect, also the state of Pakistan.